So this will be a reading of a book called State Citizenship and Rights or something. The hell? So right here. This should be recording video too. So by John Hopkins, the year is 1918, and it's literally called The Privileges and Immunities of State Citizenship by a guy named Roger Howell. I'm going to read a specific chapter because I figure I kind of know the rest of the chapters. But this right here is one, right? So it's rights not protected against discriminatory legislation. From the earliest times in the judicial interpretation of the Comity Clause, it has always been affirmed that there are certain kinds of public or political rights which do not come within its operation. With regard to those rights, the states have always been considered as constitutionally able to make such regulations as they may see fit. And you guys know, the Comity Clause is just to be able to, for the same law in another state to apply to you also, meaning that the other states won't be discriminatory against you and so forth like that. At least that's what the federal Constitution protects. And it is held that no one is entitled to exercise them except in accordance therewith. They may be said generally to include two classes of rights. One, political or municipal privileges. Right? So these are the ones that we're accustomed to and we don't understand because we live in a city and a town. Such as the right to vote, to hold public office, and to follow certain professions or occupations vested with a particular public interest. This right here is important to understand. To follow certain professions or occupations invested with a particular public interest, like open for public, like Walmart. Right? You got certain, or just an occupation that deals with public safety. That could be one too. Right? These things are in their house. Professions or occupations vested with a particular public interest. You are entering their house with this type of business. The right to, and have a right to be regulated. Right? You are dealing in the public. They have a right to regulate your behavior, that business behavior. The right to make use of those things in which the state is vested with a proprietary interest by acceptance of Judge Washington's dictum in Cornfield versus Coriel to the effect that the rights of citizens of the several states secured by the Constitution were those in their natural nature, fundamental, belonging to the citizens of all free governments. Rights of the special character above described were necessarily excluded. And although the basic idea of this decision is no longer to be regarded as authoritative, nevertheless, the distinction drawn has been so generally followed as to be now firmly established. Political privileges. The two main political privileges granted by the states to their own citizens are the right to vote and the right to hold public office. At the same time of the adoption of the Constitution, there seems to have been a well-defined and generally entertained feeling that whatever rights were included by the Comity Clause, these two at least were an entirely different nature. So they're saying whatever the Comity Clause was protecting, right? These specific ones, citizen right to vote and a right to hold public office, are of a different nature completely. Meaning the Comity Clause don't apply to that right there. That's something else that the state gives you, right? The Comity Clause is the things that the federal government's protecting you to be able to go do in another state. But this right here, the vote and the hold of public office, is dependent on that state, on what requirements they might have, like residency and so forth. These two, at least, were of an entirely different nature. This fact is evidenced by the dicta in the effect in several of the early cases. They give some annotations, but they don't give nothing. It was apparently never supposed that the citizens of any state, upon their removal to any other state, meaning you just traveling over there, right, might lawfully claim by virtue of the comity clause the right to exercise such privileges, meaning the voting ones, right, because they had enjoyed them in the state from which they had originally come. As a consequence, there are few cases in which the question was a subject of litigation, and the courts themselves apparently deemed the whole matter so evident that they were usually content merely to state the fact without going into any discussion of the reasons for their conclusions. Indeed, it may reasonably be supposed that they regarded as axiomatic and in no need of supporting arguments the fact that political rights were entirely within the power of the several states to regulate, which is the voting, which is why you're going to learn this year with the state's power to confer voting rights on all these illegal aliens that are in the country. You guys will learn this year on the power that the states still have. It is not completely dependent on the federal government. At least the state portion, right? The federals could do what they could sign and do what the fuck they want with their shit. This feeling of the courts was most probably based upon the universally prevailing and accepted doctrine of natural rights. As a consequence of this doctrine, there was a widespread belief in certain fundamental rights to be enjoyed by the members of any body politic of necessity, because demanded by the law of nature. Insofar as these rights had assumed definite shape in the mind of any one, they consisted of the rights to acquire and hold property and to contract with relation to the same. These rights being conceived of as inherent in the idea of citizenship were, as a matter of course, those which were commonly regarded as guaranteed by the comity clause. But any others not being inherently possessed by the citizens of every political society were to be considered as for the individual states to grant to or hold from whatever they pleased, from whomsoever they pleased. In view of the fact that the so-called natural rights theory was at the time accepted practically without question, it is not to be wondered that the judges in the early cases were so positive in their statements as to the exclusion of political privileges from the list of rights to be shared equally by the citizens of the states. And you see this a lot with these cases that, like Minor and Happenstance, this is a citizenship one, a voting one, I think. And then you have the Corfield one. What is what's the other one? The one about corporate rights and that corporations are not citizens, right? And it's an early case too. All of those early cases expounded natural rights protected by the Constitution. So a lot of the courts, when they spoke of it, they didn't speak in regards to your right to go vote. Right? Those things are not what they were considered like natural. At least what this guy is trying to say in this chapter. That they were given by government, which if you read more on citizenship and the right to vote and all that, that is what it is. You gave them the power to decide who gets the vote in the state or whatever jurisdiction, whether it's federal or state. As people, right? As people, we gave them the power. In their statements as to the exclusion of political privilege from the list of rights to be shared equally by the citizens of all the states, while at the same time feeling no necessity for giving their reasons for so thinking. As has been elsewhere pointed out, this is annotation, and they don't give nothing there. The accepted view of the courts is now that, generally speaking, whatever privileges are extended by a state to its own citizens must be extended likewise to the citizens of other states. With this in mind, it becomes necessary to find more stable ground than the now obsolete theory of inherent rights upon which to base any class of privileges as entirely within the regulatory power of the state. Because if they did that, they would be regulating our natural rights, and they don't. They regulate our, well, they do regulate some of those rights in regards to a contract, though, and most 9 out of 10 times it's a commercial contract that you're involved with. Like the most simple one, best example I could give, right, is a 501c, right? Whatever structure you're creating, it's still a 501c organization, meaning it's created by federal statute. The federal statute says that for this entity, you will not pay income taxes. You do have to report it, your income, but you do not have to pay income taxes. But then they give you a list of restrictions of things you can't do. Well, number one is you cannot have a political voice under that organization. That's a restriction on your fundamental right to free speech and so forth. That's an example right there. And it's damn near entirely harmless, right? But nonetheless, it's still a restriction. The whole relationship of the right of suffrage to citizenship is reviewed at some length by Chief Justice Waite in Minor versus Happers. This is a good case. If you guys haven't read this, man, it's 21 Wall 162, or Lawyer's Edition here too. Lawyer's Edition has a lot more information. They give annotations and other comments by judges. The court says in that case, it is clear we think that the Constitution has not added the right of suffrage to the privileges and immunities of citizens as they existed at the time it was adopted. So they're saying the right to vote is not a natural right or whatever, but here they're already calling it privileges and immunities of citizenship as they existed at the time it was adopted. This makes it proper to inquire whether suffrage was coexistive with the citizenship of the states at the time of its adoption. If it was, then it may with force be argued that suffrage was one of the rights which belonged to citizenship, and in the enjoyment of which every citizen must be protected. But if it was not, the contrary may with proprietary be assumed. And it's not. They're separate. Like I say, you guys will find that out in the state that you're in. You guys can actually look it up now. You can look it up on the voting, it's applications for the for the Social Security Administration. Damn, what was the application for? It's identification purposes. No, I forgot what it was. But you'll show you the amount. Like in Texas, just in Austin, in the county of Austin, right? Whatever county that is, they had like 2.1 million people applying for that card, right? For whatever it is they're receiving, and literally the statute says that they will be allowed the privilege to vote in a federal election, and that should be 100% illegal, like through the door, 100%. Like how that is, I don't know. What is the benefit? Because they're getting it through a benefit. Like, hey, okay, sign up for this. Okay, now you could do this. So whatever that is. Passing on to the consideration of the regulations of the various original states, the court finds that in each of these only a restricted number of inhabitants of the state were allowed to exercise the franchise, from which fact it is deduced that there was no thought in the minds of the framers of the Constitution, but that the right to vote was one entirely dependent on the pleasure of each state. As further proof of this, it is said, by Article 4, Section 2, it is provided that the citizens of each state shall be entitled to all the privileges and immunities of the citizens in the several states. If suffrage is necessarily a part of the citizenship, then the citizens of each state must be entitled to vote in the several states precisely as their citizens are. This is more than asserting that they may change their residence and become citizens of the state and thus be voters. It goes to the extent of insisting that while retaining their original citizenship, meaning like the citizenship of the state that you're from, they may vote in any state. This, we think, has never been claimed, which is true and how it is to this day. You can't go vote in another state when you are a citizen of another state. You have to go and become a member of that state, whether that's residency or complete domicile change. It all depends on that state. Although it is by no means asserted that the right to vote is not one which every state may regulate at its pleasure, nevertheless, it is not believed that the reasons given in the leading case on the subject are particularly substantial. The court admittedly decides the question on the ground that as people have acted with substantial uniformity for a considerable time upon a certain idea, to wit, that citizenship does not confer the right of suffrage, this fact in itself is sufficient reason upon which to base a decision. But as has been pointed out, the idea upon which the people had acted in this instance was based mainly upon the unstable foundation afforded by the theories of the natural rights school of political philosophy with respect to the inherent and fundamental rights appertaining to citizenship. As a result, we have an anomalous condition of affairs that the Supreme Court in effect bases its holding upon a theory that has been tacitly, at least, entirely abandoned. This only, like I said, they're only talking about for voting here. Suffrage. Nevertheless, the fact that the right to vote is not a right which the citizens of the several states may exercise free from discriminatory legislation must be regarded in the light of judicial decision as firmly established. It is certain that the states may prescribe conditions precedent to the exercise of the franchise, such as attaining a certain age, belonging to a particular sex, a residence within a state for a specified length of time. And these, the most famous ones, of course, right, is what? The state constitution in New York did not allow women to vote. So that's what you have Anthony versus the United States, right? She filed in the federal court that the states were violating her 14th Amendment rights for not allowing her to vote. But the 14th Amendment did not stop the states from discrimination over sex. And this case, the one that he was talking about, the Happersat, right? That case was based on a European who came here, never officially applied for U.S. citizen through naturalization, but his actions, all his activities that he was able to keep a record of, established that his intent was to become a citizen. And from that, he wanted to sign up for the militia, actually, not the military or the Navy or nothing like that. He signed up for the militia. And through that, then that's what the whole court case is about, is because of the militia part. The militia didn't the statute didn't conceive him as a citizen because of the proper paperwork. But through court, he was able to show his intent of domicile. Right? Your intention and your activities show this. And with that, he was declared that to be a citizen or whatever, and this is an intent and so forth, and he got into the militia. But what if a state should discriminate between its own citizens and those of other states in the exaction of such requirements? This is a question which has never arisen and which is not probable would ever arise. But it is sufficient to show the possibility that the comity clause might be applicable to certain instances, even to exercise of political rights. The Supreme Court has said in another case that the state statute in regard to voting might conceivably be regarded as a violation of the privileges and immunities of a citizen of the United States, which was a precise point at issue in Minor versus Happersett. It would seem that the statute might be conceivably be a violation of the privileges and immunities of the citizens of the several states. Now, you guys understand, right? This right here, citizen of the several states, right? This is the first national characteristic of a citizenship. So the question is, what did it take for you to fall under us to be a citizen of the several states? Even more so when you understand that it is this term, this class of persons, who the federal government protects their fundamental rights on. Those are the privileges and immunities. Right? The federal government protects the rights of citizens of the several states. The question is, when are you one of these citizens? When does this national criteria characteristic fall? When are you wearing this hat? If you guys understand trust law, right, and the different hats you could wear, the question is, when are you wearing this hat? As a state citizen, this is not the same. State citizenship rights and the rights of citizens of the several states are different. They could be the same, but they're protected by two different governments. And the 14th Amendment, all that did was state that if you were born in one of the states, you become a U.S. citizen. So now the question is, what does it take to fall under the characteristic of that national citizenship? What activity are you doing? What property are you using? What hat are you wearing? It's that. That's exactly what it is. You know, if you are a state citizen solely within your own state doing business, there's no interstate commerce, you're not receiving federal benefits, you're not receiving this and that, then at what instance does the federal government is stepping in for protection? There isn't one. You're not wearing that hat. You're wearing a state citizen hat. You travel to Indiana, right, without changing your domicile, you become a citizen of the several states protected by the government. When you travel to Mexico, you become a U.S. citizen protected by the federal government. Those are when you're wearing those hats. I don't mean to laugh, just it's obvious for me, but it's each their own. The right to hold public office links itself naturally with the right to vote, upon which it may be said partially at least to be founded. The comments which have been made upon the exclusion of the right of suffrage from the operation of the Commandancy Clause apply with equal validity to the majority of the cases under this head. In the case of the right to hold public office, however, much stronger and more satisfactory reasons may be adduced as to why this right is entirely within the control of each state. One who holds public office is the agent of the state. The office itself is nothing more than a mere delegation of authority from the state to be exercised in its behalf. Let me highlight that right there. Should I highlight other stuff? In choosing those who are to act in its employ, the state is at no greater disability than any private individual entering into similar contract of employment. Look at that. What does that doctrine say? The Clearfield Doctrine, right? The government becomes no different than a private individual when it comes down. They're talking about employment here, but it's no different. It's contract. They're talking about contract. They come down to our level. They don't have no more protections. And you don't either, because you are in a contract too. You don't have certain protections no more, just like they don't. You can't be in that contract to be protected. You know what I'm saying? Like there's There's things that must exist before that. An exactly analogous question presents itself with respect to the power of the state to provide that only certain classes of workmen shall be employed to labor on public buildings and other improvements, a power which had been upheld in recent years as against several rather than unfavorable earlier decisions. Let me see what this annotation is. So this is number 4. It's pretty long. I should have read that. So they quoted off this. I'm going to read this. The sentence that it's coming off of is the Supreme Court has said in another case that a state statute in regarding to voting might conceivably be regarded as a violation of the privileges and immunities of a citizen of the United States, which was the precise point at issue in Minor versus Happenstance. So in Pope versus Williams, the exact language of the court was, it is unnecessary in this case to assert that under no conceivable state of facts could a state statute be in regard to voting be regarded as an infringement upon or a discrimination against the individual rights of a citizen of the United States, removing into the state and excluded from the voting therein by state legislation. So they're telling them like this. Who do you think they're talking about here in terms of citizen of the United States? It will be one question, right? But here they're saying that it's no conceivable state of facts could, upon the discrimination against, what the hell, I just skipped this station, in regard to voting, be regarded as an infringement. So they're saying they could restrict, and it's not a discrimination against an individual rights of a citizen of the United States who's in the state that he's in. It just says removing into a state, right? It doesn't say he's domiciled there. And that he's excluded from voting by legislation. In this context, the citizen of the United States, they're not calling it the federal citizen. They're saying just a citizen from any other state here. That's how I view it. I don't view it as they're talking about a federal citizen. They have to be talking about each individual state citizens as they travel to other states. They should have used properly, probably, citizen of the several states. But then citizen of the several states don't have voting as a protection, as one of their fundamental rights being protected. A citizen of the United States does. You see the difference in those rights? The question might arise if an exclusion from the privilege of voting were founded upon the particular state from which the person came. Excluding from that privilege, for instance, a citizen of the United States coming from Georgia and allowing it to a citizen of the United States coming from New York or any other state. In such case, an argument might be urged that the citizen of Georgia was by the state statute deprived of the equal protection of the laws. Other extreme cases might be suggested. I don't know. A lot of this is a little obvious to me. It belongs to the state as guardian of the It belongs to the state as guardian and trustee for its people and having control of its affairs to prescribe the conditions upon which will permit work to be done on its behalf or on behalf of its municipalities. Let's see what annotations give it. They give a case, Atkin versus Kansas. In order then to justify discrimination by a state in favor of its own citizens with respect to holding a public office, it is possible to get away from the vague grounds upon which the courts have been content to rest the power of the state to regulate the exercise of the franchise. The franchise meaning voting, right? So voting is a franchise that belongs to them. You don't have to vote. Better, if you ever want to vote, the only reason why is because you want to benefit from the guy or the party that you're voting for. you live in some municipality that person's office has power to give you free shit. Just so you know. That's local and federal. Well, sometimes you just have to vote locally, though, right? Because it affects other aspects that do not deal with the federal government, interstate commerce, and the public welfare and all the other shit. But nonetheless, it's always because you want to receive something in return. Instead, recourse may be had to the proprietary power of the state, in accordance with which, as will be seen presently, the state may take measures to reserve public property for the use of its own citizens. This power of the state rests upon a well-established principle of England and American law, and is therefore eminently more satisfactory than a power based upon fundamental rights and the general feeling of the public for any given length of time. Where the same principle could be applied to state regulation of the suffrage, however, it is not clear. One thing I want to state too, that Happersett case. So this book was written in 1918. Happersett is 1862. So this has like 50 years on it. He's using case law that goes back before the passage of the 14th Amendment. Actually, 2 years before the passage of the Civil Rights Act that ultimately became the 14th Amendment. Where the same principle could be applied to state regulation of the suffrage, however, is not clear. The power of the state to discriminate in favor of its own citizens in respect to the holding of public office may be pushed to a considerable extent. For instance, it has been held that the right to act as executor or administrator of the estate of a decadent, it's either decadent or decedent, may be entirely restricted by a state to its own citizens. So here they're discriminating right here. But they're discriminating in favor of their own citizens and not just travelers and persons that are residing in. This is upon the ground that the holder of such a position receives his powers only by the active consent of the courts and is at all times subject to their control and direction. Acting under the control of the agents of the state, he thereby becomes an officer of the state in a public or at least quasi-public capacity. I want to read this again, right? Because it's going to be this paragraph. It says, the power of the state to discriminate in favor of its own citizens in respect to the holding of public office may be pushed to a considerable extent. For instance, it has been held that the right to act as an executor or administrator of the estate of a decedent may be entirely restricted by a state to its own citizens. So they're basically saying right here that they have the right to not allow someone from Illinois to be an administrator for someone in Indiana. This is upon the ground that the holder of such a position receives his powers only by the active consent of the courts, and is at all times subject to their control and direction. Acting under the control of the agents of the state, he thereby becomes an officer of the state in a public or at least quasi-public capacity. That's crazy. This paragraph would go, like if I was writing annotations or something, right? This paragraph would go somewhere with my equity folder. Dealing with the courts in terms of the powers that they have. The power to control property of a deceased person to the end that it shall be applied to the payment of the just debts of the decedent for the protection of those who were peculiarly. This word right here does not mean peculiar, right? This means monetary. Let's see if it comes up. Peculiarity. Nah. Let's see if it'll come up legal. More than usually. Let's see if maybe I got the wrong word. Legal definition. I have to look it up in another dictionary instead of online. Or it just types in blacks. I don't know, fuck it. I'll look it up some other time. I might have the wrong word, but fuck, peculiarly dependent upon him. A pecuniary. I forgot. Sorry. And who may otherwise become burdens on the public, and the remainder be transmitted to the persons or to the purposes the testator desired it to go or to be applied to, rest in the state in its sovereign capacity. In exercising this governmental function, the state has the clear right to call to its aid and to invest with official powers only such persons as are residents within its territorial limits. And they give you a case right here that it's above, right here. It's an Illinois case. Man, I might look that up right here. And let's look this up right here. They quoted that case in there. I'm going to have to get this at the law library. As I use Google Scholar, I'll look it up in Google Scholar. Get these PDFs too. Terms and conditions. I'll deal with that later. It should be noticed that although the functions, let's see, if people still in here? Oh, so at least a couple of people are still in here. Where'd it go? It should be noticed that although the functions of executors and administrators are in many ways analogous to those of trustees, it has been held unconstitutional for a state to discriminate against the citizens of other states with regard to the right to act as trustee. And they give a case. Ruby versus Smith, an Indiana case. Things like that I'll want to read. Is that the thing right there? No, 131. But that'll be a case just on what it says right here. Because the trustee is considered a natural. When you create an express trust, a contract that's created without statute, right? All you're doing is contracting with another living person. And you're giving him powers to do stuff with that property. Okay, well, that's still a natural person who's protected by the federal and state constitutions. His rights are protected by the Fed. That means he could go travel to other states and act accordingly and receive whatever protection he receives from those other states. It doesn't change. This distinction seems a just one, for trustees derive their powers directly from the voluntary creators of the trust, right? So they receive their powers from the grantors and are in no sense officers of the law or of the courts. Let's highlight this whole thing right here. They give another case here too. Shit, I'm just gonna highlight this whole thing right here. For me, like, I'm a reader, so it's like reading books, like if you're a reader at all, like this is what you need to be doing right here. You look up what they're talking about. You know, they might tell you something here, but they don't give you the context. So like, damn, that sounds nice right there. Okay, let's go look up what the context was. So now you go read the court case or whatever the source of information was from. To me, that's like a given. You can't, just can't take anything for as is. That any person holding even a quasi-public office and in any way responsible to the state for his actions may be required to be a citizen of the state is further substantiated by a recent decision holding that a city may properly restrict the business of a private detective to citizens of the state as being a business of a quasi-official character. So they're saying, well, I wanted to say detective, right? That's a form of, they can't stop you, or they could just restrict it of how it's being achieved in their state. But look at, they're telling you, even a private detective is considered, quasi-official character, quasi-public. And that, you know what, that's exactly what your trust would be with the assets and property and whatever else from your straw man. Because a private detective, that's a private individual doing a thing that's governed by public law, public policy, or whatever else. How would that not be a similar scenario? Let me give you more cases here. In several early cases, the right to follow certain professions or occupations affected with a public interest was declared to be dependent entirely upon the will of the state. Right? And they're saying early cases. And subject to whatever regulations it should think proper to impose. But a lot of these cases were judged, were not as restricted as they should have been. Meaning that some callings, vocations, occupations are natural to a person. So it's like a lot of these things in some court cases that have been somewhat overturned, partially overturned, but not wholly. And this decision was based upon similarity of reasoning with the right of the state to extend the franchise or to grant public office to certain favored classes only. And this decision was based on the similarity of reasoning with the right of the state to extend the franchise. So they're saying only with the franchise that an occupation that utilizing one of their franchises that affects the public interest. Thus, state statutes restricting the practice of medicine or law or of the selling of liquor were upheld on this ground. For reasons similar of those previously mentioned, the right of the states to do this was not seriously questioned, and the courts did not endeavor especially to find any particular ground for the decisions beyond saying that such privileges were political in their nature and not dependent on citizenship. Well, they're saying the sale of stuff, right? Restriction, and you're talking about an office that has a quasi-official character, right? One of their franchises. At a later period, however, there was considerable litigation upon this question, and the state laws involved were then justified under the police power. A discussion of the cases arising in that connection and the principles laid down by them is entered into elsewhere. So they don't have it here. They say here, chapter 5. in this book, but chapter 5. Keep that highlighted and go read that later. Man, how many more pages this is? Oh, it's too many pages. Oh, it's 79. It's still 10 more pages. Let me see what this one is. Proprietary interest. Besides what have been termed by the courts political privileges, it has been settled that the citizens of the several states are not entitled by virtue of the Comity Clause to enjoy upon equal terms with the citizens of any state the use of property in which that state is vested with a proprietary interest and which it holds for the general benefit of its citizens. And that's what I'm saying right here. Property that is within their jurisdiction. Use of property in which the state is vested with a proprietary interest. And for the most part, that's like natural resources and shit like that. So, but of course, among others, right? But here's the catch, right? When I tell you stop using their shit, they're telling you right here, right? I mean, they're stating it and giving you a court case with it, and which it holds for the general benefit of its own citizen. The legal theory upon which the idea rests that certain kinds of property are held by the state in trust for its citizens. Look at that. In legal theory upon which the idea rests that certain kinds of property are held by the state in trust for its citizens runs far back into the law of England. As in all countries where the feudal system prevailed, the title to all property within the country was originally in with the king, who could grant it away to whomever he pleased. The king, says Blackstone, is the universal lord and original proprietor of all the lands in his kingdom, and no man doth or can possess any part of it but what has mediately or immediately been derived as a gift from him to be held upon feudal services. And they're referencing Blackstone's commentaries right there, page 52. By Magna Carta, a restraint was imposed upon his freedom with respect to granting rights of fishery in running waters. And although the effect of this limitation upon the king's power of grant was a matter of dispute, it seems to have been generally conceded that since that time, the royal prerogative did not include the power to grant exclusive fishery rights in navigable waters. And they give you a case here. This has to be here, but this one has to be over there in the UK or something in England. In such rivers, Lord Mansfield, the fishery is common. It is prima facie in the king and is public. The title to the waters and the soil under them was still in the king, but he held it as a representative of and a trustee for the people of the realm. On the settlement of the colonies, similar rights passed to grantees in the royal charters in trust for the communities to be established. At the American Revolution, these rights, charged with a like trust, became vested in the original states within their respective borders, subject only to the rights surrendered by the Constitution to the federal government. So these are, limited delegated rights, right? I'll highlight right there. Yeah. The same theory was extended to the case of the acquisition of territory by the United States, whether by cession from one of the states or by treaty with a foreign country, or by discovery and settlement. The same title and dominion passed to the United States for the benefit of the whole people and in trust for the several states to be ultimately created out of such territory. On the creation of these new states and their admission into the Union, the same rights vested in them as were already possessed by the original states in this respect. They give another court case here. United States Reporter went all the way to the Supreme Court. Very early in their history, the various colonies passed acts with regard to fisheries and oyster dredging and planting, which prohibited non-residents from taking fish or oysters from their territorial waters, which there are a lot of cases like that. I think it's the mayor of Baltimore versus some case where he was trying to use the one of the rivers that borders New Jersey. I forgot what the hell it was. That borders New Jersey, and the other state restricted him because he wasn't a citizen from that state. They didn't allow him to do it on their side of the river or something like that. These laws remained in force after the Revolution, and the question was quickly raised with respect to their constitutionality. Now, the question that I would ask here, right, on how they're saying this, the government is looked at as the owner of that property or in regard as an agent holding it for your behalf. But they're holding in the behalf for the whole public, and they're creating regulations for the use of that for the public that's being construed as their citizens. Where the U.S. does it for everybody, tries to, right, under the U.S. Citizen umbrella, but the state does it under the umbrella of their own citizens. The thing, the notice though, this is their jurisdiction. This is what you need to highlight from this whole reading on this chapter, right? Is this is their jurisdiction they're talking about. They're talking about their quasi-governmental organizations, even a private detective, right, is quasi-public. You're entering their jurisdiction with with a specific activity, not all activities, but something specific. The activity that you're trying to do, the property that you're trying to use, it's within their realm. You know what I'm saying? It's within the use for the people, and they got the right to regulate it by us giving them that power in the constitutions.
Attornment.
Attornment?
Yeah, attornement's where you transfer property rights to someone else.
Yeah, but they're not giving them complete control. It's not ownership. It's more closer to a bailment because you give them either the legal title of it, but not possession, or vice versa, or like a caretaker. I don't know, but that's the position that they hold. It's just that we don't know all those processes that they use to benefit from. That's really where we're really getting hit at. But just to point out, though, this is their jurisdiction. Now apply this concept to employment and commercial law and everything else. This right here, I would apply this to if I wanted to start a business in fire protection. Why? Because it deals with the public. It might be a private business, but I'm going to be regulated by them because I deal with the public. Now, could I have a private fire protection business and only deal with other private organizations? Probably. And I don't have to deal with nothing with schools, public. Walmarts are open to the public. Costco is not open to the public. How about cities? I'm using cities in a broad term here, right? Because a city is really something that's incorporated, right? But you have cities, for lack of a better word, that are not incorporated, that don't have municipal regulations all throughout their whole town, their whole city. I've been to a couple, I know of a couple that I go to. No stop signs, no police department. They got private protection. No fire department, but they hire the fire department on the next city over. Could I actually do business with an organization just like that? Absolutely. Would that be 100% private? Probably. Because they are not state actors. They are not in a quasi corporate, business or whatever. I'm not benefiting from within their jurisdiction. Even though fire protection deals with the public to a certain extent. So they want to regulate it in public venues, public events, public places, open to the public. These laws remained in force after the revolution, and the question was quickly raised with respect to their constitutionality. It was claimed that since these fisheries were held by the state for the common use of all its citizens, the right to enjoy them was a privilege of all such citizens, and that a citizen of another state could no more be excluded from the exercise of this privilege than he could be prohibited from enjoying any other privilege or immunity accorded by the state to its own citizens. The only questions from this part, right, this second part, is how much does natural law affect this, right? If you're a starving individual and you're not going to this fishery or whatever for in the pursuit of income and profit, how much of natural law overrides this municipal characteristic, this police power that they have here? That's not, in the way they're talking about here, they're not including it that the use of this is a natural right. But the thing is, the activity to feed yourself is a natural right. So this activity for sure can be restricted by the government if you're using it for profit. It would be under some type of a test if it would be restricted under a natural right, like to feed yourself. I won't even use a natural right, because natural rights would be more along, when I would say natural rights are or what has been described under the protections of the constitutions and stuff, right? And of course, all the ones unsaid. I would more like to say when a motherfucker's hungry and he needs to eat, that's a primal right. That's a primal activity. That's no stopping him from going to go eat, right? But that's a debate. That's a case that you would have to go find and read to see how that has been argued. And I guarantee there's people who have won that, no doubt. Man, my wife, she's almost done with dinner. The first case, I'm gonna stop reading when she's done with dinner. This goes to page 79. So I posted the book if you guys want to read it, the rest of it, or the rest of the book. The first case in which this claim was raised is in Cornfield versus Coryell. The Judge Washington, after giving his often quoted outline of the privileges and immunities protected by the Comity Clause, goes on to say this: we cannot accede to the proposition which was insisted on by the Council, that under the provisions of the Constitution, the citizens of the several states are permitted to participate in all the rights which belong exclusively to the citizens of any particular state, merely upon the ground that they are enjoyed by the citizens. So they're saying merely because, Illinois citizens enjoy something, that's not a reason enough to say a person from Indiana should enjoy those things too, especially if they're not part of the Comity Clause, right? The natural protections, the natural right protections that the federal government is supposed to protect. Much less that in regulating the use of the common property of the citizens of such state, the legislator is bound to extend to the citizens of all the other states the same advantages as are secured by their own states. So they're saying they're not inherently have a right to that privilege or whatever, but they're saying that the state has the right to give them that privilege. Several, but of course, under restrictions, under regulations. A several fishery, either as the right to its respects running fish, or such as are stationary, such as oysters, clams, and the like, is as much the property of the individual to whom it belongs as dry land or land covered by water, and it is equally protected by the laws of the state against the aggressions of others, whether citizens or strangers. Where those private rights do not exist to the exclusion of the common right, that of fishing belongs to all the citizens or subjects of the state. It is the property of all, to be enjoyed by them in subordination to the laws which regulate its use. They may be considered as tenants in common of this property, and they are so exclusively entitled to the use of it that it cannot be enjoyed by others without tacit consent or the express permission of the sovereign who has the power to regulate its use. This court case was like 1840s, I think, because the Paul versus Virginia was the first one who really talked about your private rights in regards to public rights. And in that case, they talked about corporations and how corporations were not citizens under Article 4 as, described, right? So this case came out like, I want to say 30 years at least, right? And they came out with more detail on the defining term of privileges and immunities under a citizenship of the several states of the Union. So that means that it is the privileges and immunities that the federal government protects. That's Article 4, Section 2 or whatever. Those are privileges and immunities that the federal government protects. That are natural rights, right? This decision was regarded as controlling by the various state and federal courts in all the similar cases arising in the following 50 years. They are a unit in declaring that the denial of the right of each state to regulate the use of the common property of its citizens in any manner which it might see fit would be to annihilate the sovereignty of the states and, in effect, to establish a consolidated government, which is what the fuck they're doing now because they basically leased, rented, fucking a bailment, or an easement or something to the federal government. Like, right, you know how the federal government funds some of our roads and shit? And that's literally what they did right there. They annihilated their sovereignty with the shit that they contracted in with the federal government instead of doing it with us. This opinion was carried so far that in one case it was held that a state could properly prohibit its own citizens from employing citizens of other states to gather oysters for them. So at some point, this opinion was so strong that they prohibited their citizens from employing other citizens from other states. But it doesn't say what type of entity, like if they're using one of their franchises. But I don't know. It's a regulation though. So I don't know. I got to read the case to see what type of entity it was. Right here, Hanley versus Compton, New Jersey case. This would seem to have been rather a forced interpretation of the rule laid down in Cornfield versus Coryell, since such a holding in effect restricts the rights of citizens of other states to contract upon equal terms with citizens of the domestic state. And that's true. You're supposed to, the federal government, right, the citizen of the several states of the Union is protected to be able to have the same rights in civil manners, in political manners, to when you go to another state, like the right to contract with people, to be able to contract with someone in that state the same way as a citizen from that state would be. Right? Contract upon equal terms with citizens of the domestic state. And the propriety of this decision seems somewhat questionable, particularly since the non-resident was not engaged in gathering oysters for his own use, but for that of his employer. Nevertheless, in spite of the uniformity of these decisions, there seems to have existed some doubt to the correctness of Judge Washington's reasoning. For example, in Dunham versus Lamphere, in which the Massachusetts law regarding fisheries on the East Coast was involved and was upheld on the ground that it made no discrimination between citizens of Massachusetts and citizens of other states. Chief Justice Shaw was somewhat dubious with regard to the decision of Cornfield and went no further than to say that it was based upon grounds which appear plausible, if not satisfactory. See, like that type of language, I don't, you know what I'm saying? Like, you gotta understand the context of what the fuck they're saying. All doubt on the question was finally put at an end by the decision of the Supreme Court in McCready versus Virginia. I don't think I read that case. In which was involved a statute of Virginia prohibiting citizens of other states from taking or catching oysters or shellfish or planting oysters in any of the waters of the state. Justice Waite said, the states own the tidewaters and the fish in them so far as they are capable of ownership while running. For this purpose, the state represents its people, and the ownership is that of the people in their united sovereignty. The title thus held is subject to the paramount right of navigation, the regulation of which in respect to foreign and interstate commerce has been granted to the United States. There has been, however, no such grant of power over the fisheries. These remain under the exclusive control of the state, which have consequently the right in its discretion to appropriate its tidewaters and their beds to be used by its people as a common for taking and cultivating fish, so far as it may be done without obstructing navigation. Because obstructing navigation would be impeding some type of federal power. Fucking commercial law or something, right? Because navigation is probably analogous to traffic under commercial law. Such an appropriation is, in effect, nothing more than a regulation of the use by the people of their common property. The right which the people of the state thus acquire comes not from their citizenship alone, but from their citizenship and property combined. It is, in fact, a property right and not a mere privilege or immunity of citizenship. Looking only to the particular right which is here asserted, we think we may safely hold that the citizens of one state are not invested by this clause of the Constitution with any interest in the common property of the citizens of another state. If Virginia had by law provided that the sale of its once vast public domain and a division of the proceeds among its own people, no one, we venture to say, would contend that the citizens of other states had a constitutional right to the enjoyment of this privilege of Virginia citizenship. So if they sell land and that they distribute the income to its citizens, no citizen of another state could say, hey, I want to enjoy that privilege too, from Virginia at the very least. So they can't do that. Which sounds right? Like, what the fuck? There was something I was going to say here, but I forgot what I was going to say. It had to do with obstruction navigation. But see, it's how it says, such an appropriation is in effect nothing more than a regulation for the use by the people of their common property. And there's another book that I have, right? They talk about where regulation is not denial or prohibition. So, like, they can't stop you from the fishing, but they could regulate the activity. Don't get me wrong, they could probably regulate the activity to where it eventually crushes you, but nonetheless, they're not stopping you from doing it. They're just telling you gotta do it in a certain way, which is just as bad in my opinion. Neither if, instead of selling, the state had appropriated the same property to be used as a common by its people for the purposes of agriculture, could the citizens of other states avail themselves of such a privilege. And the reason is obvious. The right thus granted is not a privilege or immunity of general, but of special citizenship. It should have been specific citizenship. It does not belong of right to the citizens of all free governments, but only to the citizens of Virginia, on account of the particular circumstances in which they are placed. They and they alone own the property to be sold or used, and they alone had the power to dispose of it as they saw fit. And as you're reading this, right, or I'm reading this, right, think about how if you had a trust and you had a pond in on your property, how would you regulate it? Who could use that property? You, in essence, are the government, being able to write. Well, you are the people first, right? As the grantor, you're considered the people, as a people to create the document that creates the trust, which will create the regulations, bylaws, and everything else for the use of it, right? Which the trustees stand in the persona of the state in this scenario. So what would you do? Would you not do something similar to this? Restrict people from using it? The question more likely in this scenario is, why does the state have ownership or have that power, right? Well, of course, that's the documents. Whether we believe them or listen to them, adhere to them, acknowledge them, own up to them, whatever. It's those documents. And the reason is obvious. The right is special citizen. It does not belong to the right of a free governance, but only to citizens of Virginia on account of the peculiar circumstances in which they are placed. They and they alone own the property to be sold or used, and they alone had the power to dispose of it as they saw fit. They owned it not by virtue of citizenship merely, but the citizenship and domicile united, right? And that is to say, by virtue of a citizenship confined to that particular locality, and the government being the voice. Let's highlight this whole thing. Oops. The planting of oysters in the soil covered by water owned in common by the people of the state is not different in principle from that of planting corn upon dry land held in the same way. Both are for the purposes of cultivation and profit, and if the state, in the regulation of its public domain, can grant to its own citizens the exclusive use of dry lands, we see no reason why it may not do the same thing in respect to such as are covered by water. And as all concede, the state may grant to one of its own citizens the exclusive use of a part of the common property, and conclusion would seem to follow that it might be appropriate legislation confine the use of the whole to its own people alone. Man, too many pages, 5 pages left. The reasoning upon which the court bases its holding is in place somewhat confused, and the Chief Justice has gone to what seems rather unnecessary lengths in some parts of the decision, as for example, in his distinction between general and special citizen. I don't know what they're using special as. Special in some cases for me would mean private. Like a special account for a bank would be one that's non-interest bearing. But in the law before, they used to call it a secret account. A secret account. So secret became special, but special is interpreted as private. The regarding of the privileges and immunities appertaining to the former class of citizenship as those belonging to the right of the citizens of all free governments is also open to criticism, as has elsewhere been pointed out. But whatever may be thought of these parts of the reasoning, the decision itself has ever since been followed absolutely in similar cases. And it is now established beyond the shadow of a doubt that a citizen of one state is not of constitutional right, meaning the comity clause, entitled to share upon equal terms with the citizens of another state whose proprietary interests belonging generally to the state as such. And indeed, there would seem to be no question respecting the propriety of the limitation thus laid down, if the nature of the interest possessed in this type of property by the state and its citizens is kept in mind. The interest of the latter is in no wise to be differentiated from their interest in that property over which they have actual rights of ownership. From the enjoyment of such property, they may, of course, validity exclude all other persons, which is what we're able to do in trust law. Like literally exclude everyone. That's literally one of your rights unprotected under the First Amendment. You have the right to associate and congregate with whoever you want and exclude whoever you want. And that includes government. It should not be contended that a citizen of any state would have a constitutional right to share equally with citizens of another state land or its products, in which the latter were tenants in common. And in property of the character now under consideration, the situation is, to all intents and purposes, the same. The people of any state, therefore, acting through the state as their agent, may restrict the use of such property to a few of their own number or licensed citizens of other states to use it, or they may absolutely exclude all but themselves from its enjoyment. In short, it is their own property, and they make what measures they will to preserve it for their own use. They keep using the word they as the people of that state, but they should be properly using in the representative capacity of government, because that's what it is. It's us doing it, but they're doing it for us, so to speak, right? But nonetheless, the whole thing around this whole reading right here revolves around some public quasi entity, property, or something like that. Something that deals with the public in general. That's where their jurisdiction is at. That's where Caesar's house is at, and where you're not supposed to be at. You choose to be there. I'm not saying it's a good or bad thing. It just, you as a whole, right, trying to be a private individual, should not be here. If you are an established private individual and you could do contracts and you create trust and so forth, then okay, you're already established somewhere else. Now you could create an entity specifically for whatever purposes in the public domain that you have, and doesn't tie the rest of your estate to that public endeavor that you're choosing. If you guys understood what I'm saying. Only 2 people left. Pretty good. Pretty good. The general rule upon this matter is now clearly settled, but respect to the question as to the kinds of property to which the state is to be regarded as invested with the proprietary interest, no definite agreement has been reached so that one may set up a standard by which to be guided in making a decision. See, that's the question too here. Like, what kinds of property is vested with the state? At least at this time, it's not fully settled. The cases which have been hitherto means up to now, have been up to now examined, dealt with running waters and the soil under them, together with the fish swimming in them and the beds of shellfish. Later cases, however, have excluded the idea to other sorts of property, and the subject is at present time in some confusion. The leading case in this connection is Gear versus Connecticut, which is this one, which I'm gonna see if I can find. And yes, I can. In which a statute of Connecticut was under consideration, which made it unlawful for anyone to kill certain varieties of game birds for the purpose of conveying them out of the state. So transporting them, killing the birds and then transporting them out of state. In rendering the decision, Justice White goes into a very careful examination of the nature and interest which the state has in, I don't know what this means, as a general class, Fera Naturae. Fera Naturae. Fera Naturae is a Latin term meaning nature, wild animals, which refers to any animals that are not designated domesticated animals. So feral nature, I guess. He finds that both at Roman and civil law, it was recognized that such animals, having no owner, were to be considered as belonging to, in common to all the citizens of the state. And after citing the Code Napoleon to the same effect, he goes on to say, like recognition of the fundamental principle upon which the property in game rest has led to similar history and identical results in the common law of Germany, in the law of Austria, Italy, and indeed it may be safely said in the law of all the countries of Europe. The common law of England also based property in game upon the principle of common ownership, and therefore treated it as a subject of governmental authority. Blackstone, while it's pointing out the distinction between things private and those which are common, rest in the right of an individual to reduce a part of his common property to possession, and thus acquire a qualified ownership in it, and no other in general principle from that upon which the civilians base such right. The practice of the government of England from the earliest times to the present has put into execution the authority to control and regulate the taking of game. Undoubtedly, this attribute of government to control the taking of animals, fere naturae, which was thus recognized and enforced by the common law of England, was vested in the colonial governments, were not denied by their charters, or in conflict with grants of the royal prerogative. It is also certain that the power which the colonies thus possessed passed to the states with the separation from the mother country, and remains in them at the present day. Whilst the fundamental principles upon which the common property of game rests, such have undergone no change, the development of free institutions has led to the recognition of the fact that the power or control lies in the state resulting from this common ownership is to be exercised, like all other powers of government, as a trust for the benefit of the people, and not as a prerogative for the advantage of the government as distinct from the people, or for the benefit of private individuals as distinguished from public good. Therefore, for the purpose of exercising this power, the state represents its people, and the ownership is that of the people in their united sovereignty. I'm going to highlight this whole little thing. The court went on to hold that the statute under consideration constitutional, upon the ground that the common ownership of the game implied that the right to keep the property, if the sovereign so choose, always within its jurisdiction. Although the case involved no question of discrimination against the citizens of other states, it definitely places wild game within the class of property, which under the ruling of McCready versus Virginia, the state may validly reserve for its own citizens entirely, which is what you would want, right? From the government that's supposed to protect you. And on this authority, it has been specifically so held in several cases. The power to preserve the game for the use of the citizens of a state carries with it the right to make this restriction effective by prohibitive regulations. Accordingly, the state may deny to citizens of other states the privilege of buying shotguns or other weapons for use in killing such game. In Hudson Water Company versus McCarter, a statute of New Jersey prohibiting the transportation of water into other states was upheld on similar grounds to those relied upon Greer versus Connecticut. The privilege of acquiring rights in such property was regarded as qualified by the power of the state to insist that its natural advantages remained unimpaired by its citizens, so that it may validly prohibit the removal of these out of the state. The court, however, does not go to the length of saying that a state may validly exclude citizens of other states from reducing water in its natural condition to possession within the state, though this result would logically follow, but contents itself with saying that citizens of other states were left by the statute under consideration as free to purchase water within their boundaries of New Jersey as its own citizens. They were not in the position to complain of a deprivation of any privileges belonging to them by virtue of their state citizenship. Man, I'm getting a sore throat. Man, I got 2 pages left and a half. By these decisions, the state was regarded as possessing a proprietary interest in animals, fere naturae, and in certain products of nature while still in their natural condition, and as capable, therefore, of regulating by whom and upon what conditions such property might be reduced to possession. On the other hand, there is a line of decisions with regard to certain other products of nature which hold that these may properly be reduced to possession while in their natural condition and are not subject of any proprietary interest on or part of the state. So they're saying two things here. That the state has been regarded as possessing an interest in these wild animals and in certain products that have that are natural and in their natural condition. But then they're saying there's other ones that are not. They're not stating, of course, which ones, but they're saying some things. In Ohio Oil Company versus Indiana, for example, it was held that the surface proprietors within a gas field have the right to reduce its possession of gas and oil beneath. To the ordinary observer, there would not seem to be a very essential difference between water flowing above the ground and oils and gases seeping through the earth below. The court, however, after citing several state cases in which the analogy had been drawn between gas and oil and wild animals, and these deposits have been termed minerals-free ferro-natural, says by Justice White. If the analogy between wild animals and mineral deposits of oil and gas stated by the Pennsylvania court and adopted by the Indiana court, instead of simply establishing a similarity of relation, proved the identity of the two things, would be an end to the case. This follows because things which are natural are ferro-natural belongs to the negative community. In other words, are public things subject to the absolute control of the state, which, although it allows them to be reduced in possession, like licensing for deer hunting, right, may at its will not only regulate but wholly forbid their future taking. But while there is an analogy between wild animals, and the moving deposits of oil and natural gas, there is not identity between them. Thus, the owner of the land has the exclusive right on his property to reduce the game and the game there found in possession. Thus, as the owner of the soil has the exclusive right to reduce to possession the deposits of natural gas and oil found beneath the surface of his land. The owner of the soil cannot gain when it passes from his property. Cannot gain from, because it's not on private property no more. This is a good little thing right here. This right here, Justice White right here. The owner of soil cannot follow game when it passes from his property. So also the owner may not follow the natural gas as it shifts from beneath his own property to the property of someone else within the gas field. There's a case, it's one of the Rockefeller cases. They couldn't get some property that had a large deposit, and I think it was in Texas. So they built a drill that went in diagonally. So on their property, they built a drill that went in diagonally underneath the other person's, and they end up losing in court too for that. The identity, however, for many reasons wanting. In things natural, in wild animals, in things wild, all are endowed with the power of seeking to reduce a portion of the public property to the domain of private ownership by reducing them in possession. This is important right here. They're saying that the property that the government holds is meant to be reduced. In the case of natural gas and oil, no such right exists to the public. It is vested only in the owners in fee of the surface of the earth within the area of the gas field. That should tell you something to do right there too. So you ask yourself, what type of owner are you of the property you hold? This difference points out at once to the distinction between the power which the lawmaker may exercise as to the two. In the one, as the public are the owners, everyone may be absolutely prevented from seeking to reduce them to possession by enacting by the state of a law as to the public ownership is but a discharge of the governmental trust resting in the state as to property of that character. On the other hand, as to the gas and oil, the surface proprietors within the gas field all have the right to reduce the possession of gas and oil beneath. Highlight all this right here. Eventually, I'll come back to this book. The language here used has been made the basis of the decision in Lindley versus Natural Carbonic Acid Gas Company and West versus Kansas Natural Gas Company. The one holding that mineral water sifting underground through porous rock were not property held by the state for the common benefit of the public. The other, that the state may not constitutionally prohibit natural gas and oil from being transported out of the state. A review of the cases upon this whole question leads to the belief that the sorts of property in which the state is to be regarded as vested with proprietary interest and in the use of which it may accordingly discriminate in favor of its own citizens are comparatively limited in number, and that this number will not be extended beyond its present compass. Over the animals fera naturae within its borders, the waters running upon its surface and the beds and their beds, together with the fish in them, the public lands, including possibly the public roadways, the employment upon public buildings, and probably the appointment of public office, possibly over the atmosphere and the forest within its territory. The state has full control and power to restrict their use to whatsoever and in whatsoever way it sees fit without contravening any constitutional provisions. Let's go over this again, this part. A review of cases upon this whole question leads to the belief that the sorts of property, right? So sorts of property in which the state is to be regarded as vested. So this is, today they call it the public rights doctrine, right? They call it the public rights doctrine. It's where the public, the government, has an interest in a property or some other thing, right? And in the use of it, it may accordingly discriminate in favor of its own citizens. So the state could discriminate in favor of their own, are comparatively limited in number, and that this number will not be extended beyond its present compass. So like it's not going to get any bigger, at least at this time, 1918. Over wild animals within its borders, the waters on its surface and beds, together with the fish, public lands, including, right? So all this part right here. The enjoyment, including possibly the public roadways, the enjoyment of public employment buildings, the probability of appointment to public office, possibly over the atmosphere and the forest within its territory. The state has full control and power to restrict their use to whatsoever and in whatsoever ways it sees fit without contravening constitutional provisions. Beyond this, it is not believed that such a power extends. Nevertheless, it is a power which contains within it great possibilities of extension, even within the boundaries outlined, so within the borders of the state and the persons, right? The franchises and voting and all that other shit, right? And the increasing hold which the idea of public ownership is acquiring at the present time over popular fancy may very easily serve to bring out its potentialities in a more striking manner than any which they may have so far been developed. And that was the last one. I thought I had one more page. Next page would have been discriminatory legislation under police power. But that's the end of that chapter. Hopefully you guys enjoyed that for whatever it was worth. So tell you guys again what the book is. The book is called The Privileges and Immunities of State Citizenship by Roger Howell, right? Second Lieutenant in the 17th Infantry of the United States, and printed in 1918. And I guess sponsored by a series made by Johns Hopkins University Studies in Historical and Political Science and blah, blah, blah. And the chapter that I read, was chapter 4. Rights not protected, meaning not protected by the federal government. It's not one of your fundamental rights. It's not one of your rights protected as a citizen of the several states and so forth like that. So hopefully you guys enjoyed that. If not, so be it. You guys can listen to the video again or read the book. I put it out. But that's all for now. It's time to eat and time to relax. I am going to continue reading this book. I don't know if I'm going to read the whole thing, but we'll see. Because this looks, history of the conversation, this looks like an interesting book. I just got this book a few days ago, so that chapter was the first chapter I read. I looked at the table of contents, saw the most interesting thing, and read that. All right, well, I'm going to shut off this mic. The recording, more like.